don't see too many with 20 years plus of abstinence.
Amen. She has a serious sobriety history, Judge.
I believe that's an abuse of discretion. Mr. Bauer, I have had a chance to review the pleadings in this matter and the record and your brief. I'll go ahead with the
Well, Judge, I know you've had some familiarity with these appeals yourself in private practice and what petitioner has to go through to try to get her driver's license.
I don't see too many with 20 years plus of abstinence.
Amen. And say a serious relapse history. She has a serious sobriety history, Judge. 23 years. She proved by clear and convincing evidence, hands down, that her alcohol problems are under control.
When's the last time she used heroin? When's the last time she used meth?
Exactly.
When's the last time she used mushrooms?
Yeah.
But those weren't problems.
No, exactly.
Is that the only reason for the denial?
He quoted a serious relapse history, Judge, which was the only reason for the denial. But that seemed to fly in the face of reason, in that after 23 years, she hasn't had a relapse.
Well, let's see what the Secretary has to say, and you can reserve some rebuttal.
Absolutely.
All right, Mr. Wargo.
Your Honor, as noted by the ALJ, there is a subsection in Administrative Rule 257313. Though the ALJ quotes subparagraph F, I do believe he meant to quote subparagraph D, being that the hearing officer may require that the petitioner present evidence from not less than 3 independent sources to corroborate the petitioner's behavior with respect to alcohol and controlled substances. As such, Your Honor, this is a requirement that is allowed by the administrative rules, and the ALJ was supported by clear and convincing evidence in this decision. Thank you.
Thank you. Any rebuttal?
Again, Judge, I think this was a stretch by the hearing officer. I don't know why they would deny. And this was, and the other one, judges, we've only requested the interlock device as well. We don't, was it full driving privileges? We can monitor for another year with the interlock. So I think it was an arbitrary capricious abuse of his discretion.
Well, in this case, the petitioner had 4 convictions for drinking and driving. The last one was in 2002, 23 years ago. The evidence that petitioner presented was that she'd been sober since that time. And the hearing officer made a finding to that effect, saying, quote, Ms. Witkowski's claim of abstinence from alcohol since August 2002 was supported by her evidence. The hearing officer nonetheless denied her petition for license restoration because she failed to document that she has also abstained from drugs. However, there was 0 evidence that drugs were ever an issue for this petitioner. Therefore, I believe that's an abuse of discretion. The evidence available showed that she had never used marijuana or other drugs. The substance use assessment and the drug screen showed no problem with drugs. So as I read this over, this appeared pretty clearly to be an example of a hearing officer looking for any technical reason to deny the petition, rather than objectively and dispassionately assessing the evidence to see whether the petitioner had proven by clear and convincing evidence that her substance abuse was under control and was likely to remain under control. Her 23 years of abstinence does that. There was a recent opinion as well saying that even the imposition of a restricted license with the interlock has to have some evidentiary basis. I see none on this record. I grant the petition in full and would sign an order directing the Secretary of State to restore full driving privileges to Mr.
Thank you, Your Honor.
I'm presented with a proposed order. So I've signed both parts of the first copy, and the other ones can be trued for you.
Thank you, Your Honor.
If experience tells me anything, the Secretary of State will want to see a prosecutor's signature on that as approval as to form as well. Absolutely. So if you want to review that, Mr. Wargo.
Thank you.